Thank you for attending this event. I am the chairman of the European branch of the CIArb, and this is the branch annual conference that this year takes the format of an interview. The guest star is a pillar of the Chartered Institute of Arbitrators and of international arbitration, modern international arbitration in general. I'm indeed truly honored and grateful that this guest is with us today. The interview will be conducted by our honorary treasurer, Philip Landolt of Landolt and Koch, Geneva, to whom I immediately leave the audience to introduce the guest and the other fellows who are going to interact in the interview. So, Philip, over to you. Thank you.
Thank you, Jacopo. It's a great pleasure indeed to moderate this interview of our distinguished guest, Neil Kaplan, CBE QC SBS. Neil was called to the bar of England and Wales in 1965 and has practiced as a barrister, principal Crown Counsel at the Hong Kong Attorney General's Chambers and served as a judge of the Supreme Court of Hong Kong in charge of the construction and arbitration list. Mr. Kaplan has been a full-time practicing barrister since 1995. During this period, he has been involved in several hundred arbitrations as co-arbitrator, sole arbitrator, and president. In England and Hong Kong, but also in the USA, Canada, France, Germany, Croatia, Austria, Philippines, China, Laos, Japan, the Netherlands, Malaysia, Australia, Denmark, Sweden, and South Africa. These arbitrations have included a wide range of commercial, infrastructure, and investment disputes under the auspices of all of the major institutions such as the ICC, HKIAC, LCIA, and SIAC. Mr. Kaplan's investment treaties cases under ICSID and UNCITRAL, both as presiding arbitrator and co-arbitrator, have involved, among others, Hungary, Indonesia, Timor-Leste, Croatia, Vietnam, Cambodia, Ecuador, India, and Iran. Mr. Kaplan is often and rightly referred to as the father of Hong Kong arbitration. And he was chairman of the HCIAC from 1991 to 2004, and he was president of the Chartered Institute of Arbitrators from 1999 to 2000. Since 1995, he has been a council member and now governing board member of the International Council of Commercial Arbitration, ICCA. Between 2012 and 2016, Mr. Kaplan was also a member of the ICC International Court of Arbitration. He is a chartered arbitrator and a fellow of the Chartered Institute of Arbitrators. He is a panelist of several other arbitration institutions, including CTAC. In June 2001, Mr. Kaplan was awarded a CBE for services to international arbitration. In 2007, he was awarded the Silver Bauhinia Star by the Chief Executive of the Hong Kong SAR. Since 2017, Mr. Kaplan has been the president of the Court of the Mauritius Chamber of Commerce and Industry's International Arbitration and Mediation Center, the MARC. On the 26th of August 2018, Mr. Kaplan was appointed as a member of the International Commercial Expert Committee to the Chinese Supreme People's International Commercial Court. Mr. Kaplan has written and edited several books on arbitration, as well as having written numerous articles and delivered many lectures, including the 6th Goff Lecture and the first Harbour Lecture in Hong Kong. He teaches at the City University of Hong Kong, as well as giving guest letters everywhere. And we welcome very warmly Mr. Kaplan today. Our questions are three, all from the Chartered Institute of Arbitrators European branch. First, there's Jalal El-Adab. Dr. Adab is a partner at Bird & Bird in the Dispute Resolution Group in Paris. He is the head of arbitration practice in France and a member of the DR Group in the UAE. He has 25 years of experience in the field and was involved in approximately 150 matters, 30 as an arbitrator. Dr. Adab is a former member of the International Court of Arbitration of the ICC from 2015 to 2021. He is also vice chair of the European branch of the Chartered Institute of Arbitrators as well as the co-chair of the IBA Arab Regional Forum. He sits as a member of the advisory board of the Vienna International Arbitration Center, VIAC. Our second questioner is Dr. Anna Gerdau. She is a senior associate at Derens and Garavi in Paris. She has over 12 years of experience as a counsel and secretary to arbitral tribunals, and she has arbitrated under ICSID and the ICC, the LCIA, MIAC, and the ICDR, AAA, AAA rules, and under the main Brazilian institutions rules. Her cases have included commercial transactions and joint ventures, large infrastructure projects in construction, renewable energy, oil and gas and transportation, M&A deals, and projects in real estate and for mining research and exploration. She's a member of the ICC Commission on International Arbitration and ADR, and she has a PhD in LLM in international law from the University of Cambridge. She works in French, Portuguese, Spanish, and of course, English. Our third questioner is George Lambrou, and he's, of course, an international dispute resolution specialist, a solicitor advocate, and he's regularly engaged in international arbitration as counsel, co-arbitrator, and sole arbitrator under the ICC, LCIA, LMAA, SCC, and ICSID rules, sitting in London, Athens, Geneva, Stockholm, and Washington, D.C. He has experience in construction, energy, trade, software, securities, investment treaty, and maritime disputes. He has a very strong maritime background, having been a partner for many years in a leading London-based shipping law firm. He's a faculty member of the Chartered Institute of Arbitrators and the Institute of Chartered Shipbrokers. He works in Russian and Greek and, of course, English. These are our questioners, and Mr. Kaplan, our distinguished guest. You're welcome to ask questions over the chat function, which I'm sure you're all very familiar with. There's also the Q&A function, but please do focus your questioning on the chat function. I understand that Neil will be taking any questions towards the end of every section we're going to canvass today. And so I'll turn our questioning over to Dr. Jill Adab, and let us begin.
Thank you, Philip. Let's get started indeed. And Neil, if you allow me, we'll get to the very core of this topic, which is how intertwined process and substance are. More and more, at least recently, procedure and substance have been opposed. Procedure is more and more, we would say, perceived as a burden, a hurdle. And if you may excuse my French, some people, populists, lay people would say, and even actually lawyers in their extreme positions would say, often we want to cut the bullshits and get to the point. So my question to you is, as a counterexample, can you share with us some practical examples or cases where compliance with formal procedural steps has significantly contributed to the pursuit of substantive justice?
Well, thank you very much for the question. And of course, that question goes, in a sense, to the very heart of what we all do. When I started studying quite a long time ago, I always thought procedure was a bit of a bore. I was only interested in the substantive law. And as time has come on, I've come to realize that procedure is really very, very important indeed. And to give you an example, I mean, the Chief Justice of Singapore, who's at the cutting edge of a lot of things in arbitration, just delivered a lecture, the Freshfields lecture, where the title he chose was "The Centrality of Procedure in the Pursuit of Justice." And I think that if he's come around to that view, then I think there's a lot in it. And the reason is this. Procedure and process is terribly important, because at the end of the day, what you want to achieve is that the losing party feels that the process has treated him fairly. He will be upset at having lost and maybe very annoyed at having lost. But if that person or that company can say, well, I'm furious at having lost, but I have to say, the tribunal understood my case and they gave me a full opportunity of presenting it, then the process has done its job. And so I think, therefore, it's appropriate that we spend much more time on trying to get the process to work. And if you make the process work properly, which means a lot more case management than ever before, I think we can achieve a great deal. And the one thing that good case management should avoid is surprise, because nothing is worse, particularly in the context of multicultural disputes. Surprise can be a very dangerous thing. So if you spell it all out at the very beginning, you have a really good dialogue with the parties at the very beginning, explain what's going to happen, set it all out in a procedural order when you've had a chance to discuss it with them, then I think the whole process should proceed from there and will be a lot more successful. And it's when someone's taken by surprise that the problems crop up. So I think we really do need to spend more time on case management. And one of the great advantages that's come from the pandemic and our use of virtual hearings is that you can be much more effective case manager. For instance, if you see something going wrong in a case, you can see a lot of tension in the correspondence, you can say, right, tomorrow, 8 o'clock, we'll Zoom, we'll sort this out. Now, although we've always had the ability to do this, it's not until the last 3 years that we've actually made use of it. Now, I remember you, Jalal, introduced me to Zoom about 5 years ago, and I found it too difficult to operate. And I know you looked at me at the time as if to say, your day will come. Well, it's certainly come now. I spend my whole life on Zoom. So I think that the virtuality that we're using now makes it a lot easier to case manage cases. And
thank you, Neil. Before I leave the floor to Anna for the next question, to recap, so since you were talking about the day when you will be using Zoom, what you're telling us is that it's not sufficient that a party or parties get their judgment from a court. They also need to feel they had their day in court. So it's a mix of the two. You get something and you get a positive feeling that you were heard. Anna,
right.
Yeah.
Please, Neil. Oh, so we carry on to the second question, Neil, or is there something you'd like to add?
No, it's fine.
All right. It's Anna Gerdau's question. Please, Anna.
Thank you, Philippe, for the kind introduction. Also, thank you to Jacopo and Jill for the very kind invitation to be here. It's an honor. I'm very delighted to be the interviewer or our interviewee, Mr. Neil Kaplan. And I still recall until today his proposal of an expert's protocol during a webinar, a Delos webinar, very useful. And you've been doing an admirable work and in educating also our arbitration colleagues and myself. My question relates to due process paranoia and guerrilla tactics. As Yves de Hans, with whom I have the pleasure to work, stated a few times, we need arbitrators that have the courage to decide and to take difficult decisions. And as you mentioned before, we need excellent case managers. This perhaps could reduce due process paranoia that often prevents decision-making or slows down decision-making. There is an excellent article by Klaus-Peter Berger and Ulle Jensen proposing the procedural judgment rule to reduce due process paranoia. The procedural judgment rule based on the principles of transparency, proactivity, interactivity, proportionality in procedural management decisions, encouraging not to fear state courts ex post review. How, in your experience and practice, should an arbitrator handle, first, his or her own due process paranoia, and second, guerrilla tactics by counsel? I'm keen to listen to you on this topic.
Thank you very much for the question. Of course, due process paranoia has become a topic that has been discussed quite a lot recently, because I think in one of the Queen Mary reviews, it came up as a major criticism of arbitration. I think the first thing I would say is that anyone who wants to be an arbitrator should read the decision of Chief Justice Menon in the Court of Appeal in Singapore in the Jaguar against CMNC case, because in that case, he sets out very carefully his view that when in Article 18 of the model law, when it talks about a full opportunity to present the case, it doesn't mean full, it means reasonable, which of course is what most of us thought anyhow. And he goes on at some length to encourage arbitrators to stick to their guns and not to allow arguments to go on and on and on because of the word full. And he went through the travaux préparatoires of the model law and showed quite clearly that they meant reasonable rather than full. And I think that's something that arbitrators ought to bear in mind. And again, we get back to the point I was making at the beginning, because if you have a procedure that's set out very clearly, a very full procedure with time limits and everything, and no one can complain if you impose what you've agreed. And the trouble is that because some people think full opportunity requires endless opportunity, which it doesn't, they allow the dates and the procedures that they've set themselves to be waylaid a bit by the one party who doesn't comply. So I think really the answer is you've got to stick to your guns. If you set it all out, you stick to your guns and you make people comply. Now, of course, sometimes things will happen that mean it's impossible to comply. The pandemic's an example, illness, family tragedies, all sorts of things can happen that might affect the ability to stick to agreed time limits. And of course, you have to be flexible about that. And I think everybody is. But at the end of the day, if you have a really detailed procedure set out in your procedural orders with timetables and all the steps necessary to get to a hearing, you've just got to stick to it and not allow parties to waylay you. And it means being tough sometimes. And you have to be tough because it's not just the party who's seeking an indulgence, it's the other party. The other party is entitled to assume that what you've laid down is going to be applied. So I think that you should never be looking over your shoulder at what a supervising court is likely to do. And you certainly should not be looking over your shoulder as to what an enforcing court somewhere in the world that you don't even know about might or might not do. You have to be satisfied that what you're doing is within the confines of what the supervisory court will think reasonable. And if you're happy with that, then you should just go ahead and do what you think is right and not worry about what might happen in the future. It's like when you're a judge, you shouldn't worry too much about the appellate court. You do what you think is right. And if you've gone wrong, well, someone will correct you. We all make errors, so it's not a big problem. And of course, the chance of setting aside something in arbitration is much less than in court. So set it all out, agree it with the parties, make sure they understand it, and keep in contact with the parties. Have frequent case management conferences so you could discuss all these things. And sometimes by doing that, you can sort of head off a problem. And certainly one thing you should have in your procedural order is that if anybody wants an extension of time, they have to apply for that extension of time before the time has expired. Because very often you get an application, you know, a few hours before the time limit for an extension of time, and there's a gun being held at your head. There's not much you can do. So you should try and encourage people to make their applications before the time limit is expired. Now, as to guerrilla tactics, I know this is a phrase devised by my friend Michael Huang, and he might have come across more guerrilla tactics than I ever have. I have very rarely come across guerrilla tactics. I don't know why. Maybe it's because in all the cases I do, the parties are represented by very able and internationally renowned firms, and they tend to behave very properly. And so I've not actually had any real experience. Now I think of it, I can remember one case where I had guerrilla tactics, and it was horrible. And it was an unusual case. It wasn't a big firm, and I won't go into it because it really got very nasty indeed. But it's a rarity. And I think all you have to do, if that happens to you, and you've got your procedures all agreed, is just to be very, very tough with them and not to be frightened, because what they'll do by their guerrilla tactics is try and force you to make a mistake. They'll try and force you to do something that then later they can say was a breach of due process. So it's just, again, the same thing, sticking to what you've agreed and try if you can to quieten things down. And I find that in correspondence, people can write very nasty things, but when you get them face to face, even on a screen, that nastiness tends to evaporate because it's quite hard to speak nastily towards a colleague. So I think one of the ways of doing it is to get them on the screen or in person, and they'll find it much harder to be so difficult. But I have to say, I haven't got a great deal of experience in dealing with guerrilla tactics, and I hope that I never have to. Now, I don't know if that's a sufficient answer to your question, but that's really all I can say on that point.
Thank you very much. Yeah, I liked your point on the reasonable opportunity to present one's case, and especially in the light of the fact that most challenges to awards don't succeed in terms of statistics, as you well mentioned. So I think that's a good point.
Yeah, a lot to think about. I'll just remind Neil, there are some questions on the chat here and now. If you wanted to attend to them at the end of this section, yes, you are, of course, most welcome to.
Well, there is a question. There is a question there, and that is, to what extent does due process allow the arbitrators to articulate preliminary views on the merits, provided the submissions on facts have already been made? I think this is a very hard one. I don't think you can do that unless the parties invite you to do so, and not only invite you to do so, but agree that anything you say to them as a result of this request cannot be used in any challenges to what happens thereafter. I think you've got to be very careful about this. So what does the process allow the arbitrator to articulate preliminary views? I mean, sometimes the parties will like you to give a preliminary view. And if they do, that's fine. If they don't ask you, I think it's very dangerous to do so.
Neil, does that mean you're against summary judgment? I know that's one of the issues being reviewed in English arbitration.
No, I'm not against summary judgment. It's pretty high bar in arbitration. You've got to show that, you know, there's hardly any chance of success. No, I'm in favor of that, but that's because the rules provide for you to make an application. But just to say to the parties, as you might as a judge, maybe, well, this isn't a very good case, this is a very bad point, you should drop this one, is a bit dangerous in arbitration, I think. Judges can get away with a lot more than arbitrators can in that respect. And of course, in some jurisdictions, they have settlement judges who are just there to help parties settle their cases, whereas arbitrators are in charge of the procedure and the merits. So they've got to be very careful what they do and what they don't do. So I think that's a very dangerous one. I mean, it might be nice to send a copy of the award in draft to both parties and say to them, well, tell us what's wrong with this draft. And then you get another round of submissions. But I don't think so. I think that's a bit dangerous. Right.
Okay. Are we ready to move on to the next section?
Yeah.
So, well, actually, I think that brings us is a nice segue into the next section, actually. So I'm speaking to you, Neil. We haven't met before. I'm speaking to you from Greece, and as you know, there's a very long history of arbitration in Greece, going back to ancient Greece. And when the ancient Greeks were arbitrating, oftentimes there was a sort of, the roles they played was also to be that of to help the parties settle. And as you've alluded to in your previous discussion, there sometimes can be a desire, a very human and natural desire on the part of an arbitrator when they see the two parties in a dispute to want to encourage settlement, particularly when they see the one side is really just wasting their time and they're heading in the wrong direction. They'd be much better off settling. But then, of course, that provides the tension in modern day arbitration. And there's, of course, as you alluded to, you've got to be very careful about how that's done. Of course, we've got the German examples as well, where by the parties' consent, you know, the arbitrator may be invited to express some preliminary views, but that seems to be unique to Germany. Although German arbitrators that I know swear by it and say that it works and works very well. So I'm curious, you know, what is your attitude towards encouraging the parties in arbitration to settle? What are the factors which might, you know, affect your stance on the matter in any particular arbitration? And has there been any development in that attitude over the years?
Not a great deal is a short answer to the last question. It's difficult because, I mean, I remember doing a case once, which was clearly should have been settled. The parties were friendly. There was a lot of money at stake. And my chairman said, I think we should call the parties in and tell them they should mediate. I said, I wouldn't do that. He said, no, I think we'll do it. So he calls them in and he says, I think you should mediate. And they looked at him witheringly and said, don't you think we've thought of that already? So I think the answer is you have to have some trust, if you've got good counsel on both sides, that they've been through all this with the client. Of course, in China, you have the combination of mediation and arbitration. And we have that section in Hong Kong, which enables an arbitrator to be invited to be a mediator and then go back to being an arbitrator again if it fails, subject to certain conditions. And of course, that sends a shiver down the spine of any common lawyer. But the Chinese swear by it. I've only been involved in that once in a CTAC case where I was sitting in Shenzhen and the chairman halfway through said, I think we should ask the parties to allow us to mediate. So I said, well, fine, have a go. Well, we wasted 2 hours while one side said, I'm prepared to mediate, and the other side said, no, you're not. And we wasted so much time that I said, let's get back to the merits and get the case dealt with. There was a case recently I was involved in when it was blindingly obvious to me and the other wingman that the case was settleable. because I can't go into any details, but you could see a commercial answer to the dispute. The stuff was in the ground, it was valuable, certain things that had been put right, that had been complained about. And so we just called the parties in, not the chairman, we left the chairman out of it. We called the parties in and said to them, look, it's a matter for you, but we really do think this case has a commercial answer to it. And if we can help in any way by recommending a mediator, ask us. And the result of it is, after full hearing, massive closing submissions, and the award is all ready to go, we've been told not to deliver it because they are, pretty close to a settlement. So, that obviously had some benefit. Now, whether they would have got to that without a push from us, I don't know. Maybe they wouldn't. So in that sense, that was an advantage. But I think you have to pick your cases very carefully as to that. One of the things we're doing now, which might be of interest to you all, is what we call the mediation pause. We build into the timetable a 6-week period, let's say, when nobody has anything to do. There's no filing. There's nothing to be done within that 6-week period. And they know, because we tell them at the beginning, that 6-week period is for you to use for a mediation process if you want to. Now, we don't want to know about it. It's just there. And one of the advantages of it is that it stops one of the parties saying, well, I'm not going to mediate because it's a sign of weakness. Whereas they're told in advance, it's there, use it if you want to. If you use it successfully, fine, you'll tell us the case is settled. If you don't use it, we don't want to know about it. And so that's something that's come out of New York. I thought about it, and then my colleague in New York thought about it. We both wrote about it. So we try and do this called the mediation pause. And it's quite a good time to have it after the early opening. After they've heard each side open their case in full, that's a good time to go and have a think about it, because you then see how strong or weak your opponent's case is. So,
yeah. I mean, you're quite right about I think there's also a cultural element as well, as you said. So the fear of being perceived to be weak, either before the tribunal, before the other party. And so I can see why giving that pause might give permission to the parties to engage in mediation without appearing weak.
yes.
There's a question.
I see a question. There's a question there about, does the Kaplan or early opening help encourage the parties to settle? Well, I think the answer to that is it can, and it has. I've known it happen twice, where the case settles quite soon after it. And I think for the reasons I just said, if it's a good opening and you hear the other side's opening, you think, my God, I've got a few problems here, we better try and settle this. And it has happened. So having the opening and the pause together is quite a good idea, I think. Sorry, you were going.
Thank you.
You're on mute, Philip. Philip, you're on mute.
I apologize. Yeah, fascinating issue of fault line between cultures. It's Dr. Eladab's turn for a second question. Jill.
Thanks, Philip. Neil, there's another interesting point which we somehow alluded to when we talked about the facts and assessing the merits on a preliminary basis. So I would like to discuss with you whether the arbitrator, what the arbitrator can do in terms of ascertaining the truth, and to what extent the principle dura novit curia may apply or not in international arbitration. So the questions are the following, and of course, will give you a bit of background, and you can pick up whichever you think is the most appropriate question. In terms of establishing the facts and the law, can it be said that the arbitrator has a duty to guide the parties as far as the exact restitution of the facts is concerned, but is prevented from guiding the parties in indicated the exact sources of law? In another related question is whether you think there's an issue if the arbitrator is to basically rely, or rather point at a source of law, a specific one that the parties have not previously submitted, and which may actually be outcome determinative. And I'm saying also this because against the background of many common lawyers, for example, qualified under New York law, there is a duty of candor, i.e. to disclose even adverse interests. Of course, we're not talking here about the counsel, but rather about the arbitrator. And we're wondering to what extent raising those sources, whereas it hasn't been discussed, can be an issue of due process.
Well, there's an awful lot in that question, Jabal, as you know. The topic of Jura novit arbiter, I have a real problem with that phrase. I keep calling it COVID arbiter for some reason. Jura novit arbiter came up recently in the Court of Appeal in the Cayman Islands. I don't know whether you know about this case. It's called Go Linas against some airline. And the interesting point there was that this was a Brazilian arbitration under Brazilian law with Brazilian arbitrators. And they decided a point of law that had not been argued, but based on the facts that had been established. And it went on appeal to quite high appellate levels, and it was upheld on the basis that, being a civil law country, Brazil operated the Euronovit curia and arbiter principles. So far, so good. The award is then taken to a common law jurisdiction, the Cayman Islands, for enforcement under the New York Convention. The judge at first instance refused to enforce the award on the grounds that the arbitrators had decided based on a principle of law that had not been put to the parties for their comment. It then came to the Court of Appeal in the Cayman Islands, where Mr. Justice Ricks, who was sitting in the Cayman Islands, gave a very detailed and fascinating judgment on this issue, and decided that it was not against the public policy of the Cayman Islands to enforce an award that was totally in accordance with the law to which the arbitration had been subjected. Brazilian law, Brazilian procedure, Brazilian substantive law. And what is interesting is, in the course of that judgment, it was pointed out that this doctrine goes back to the time of Aristotle, because Aristotle said a litigant has clearly nothing to do but to show that the alleged fact is so or is not so, that it has happened or not happened. As to whether a thing is important or unimportant, just or unjust, the judge must decide that for himself. He must surely refuse to take his instructions from the litigant. Now, whether the doctrine applies or not in a common law context, I think is irrelevant, because I don't think a common lawyer, if he or she found a point of law that had not been argued by the parties, wouldn't dream of just deciding it, would put it to the parties and ask them for further submissions. So there wouldn't be any due process problem. And I think that if an arbitrator sees a point of law that the parties haven't thought of or argued, I think it's perfectly proper to put it to the parties and get their views, and then either accept it or not. You can't decide, you can't be bound by just what the parties put to you, because they may have forgotten something. They may have forgotten a statutory provision. You can't then give your award that's based on something you know to be wrong. So you have to put it to the parties and ask them for their view, and then you can deal with it. So I think all this argument about the arbitrator knows the law is, in a sense, academic, because from a practical point of view, I think we would all give them an opportunity to comment on something they hadn't specifically argued. Of course, they didn't do that in the Linas case, because they were, applying it as part of their domestic law. But I think most of us in international arbitration would not take that view and would rather hear further submissions on it. So that answers part of your question. What was the rest of the question?
Sorry, I was on mute. Well, the parallel I was making was also with this the fact that some common lawyers had the duty of candor, which is to disclose even adverse decisions. So I was wondering whether the cultural background of the arbitrator could also impact that question of whether to get into legal issues that haven't been discussed earlier on. Are arbitrators more likely to do that than others, depending on their cultural background?
Well, I can only speak from my own cultural background, that you do have an obligation as a barrister to inform the court of decisions that are against you if the other side haven't raised them. And you have an even stronger obligation to the court if your opponent is unrepresented. So if you're appearing for somebody and the other side is appearing in person, you have a very strong obligation to put to the court things that might help their case. Now, I'm not sure, there's a bit of a doubt about how far that applies in arbitration, because this is part of a code of conduct, as it were, for appearing in court. But it's hard to sort of throw those views away when you suddenly appear in arbitration and not in court. But luckily, there's very few cases where parties are unrepresented. But of course, sometimes they're badly represented. So you may have a top firm on one side and a very inexperienced firm on the other, who don't seem to understand what the case is all about. And then you have to be very careful. You mustn't coach one side, but you have to find a way of making sure that it was a fair contest. And that is a very difficult line to draw. But fortunately, in my experience, it doesn't happen very often. I remember it happening once. We had the same thing, a top law firm on one side and a very small outfit from China on the other side. And we had to help them a bit because they didn't understand the procedure. They didn't know what to do and when to do it. But, it didn't make any difference in the end. But, at least they felt that they'd had an opportunity of presenting their case and understood the procedure with some assistance from everybody. That's all I can say really on that.
Thank you, Neil.
Thank you.
I may add on the Brazilian case you mentioned, Neil. I recommend the people that are listening to us today to reading it, especially the Court of Appeal decision. And the question about Yuri Novic Curia was a legal characterization. The tribunal found there was malice of a third party, and this provision of the Brazilian Civil Code was featuring in an expert report, but not it was not in the pleadings of the parties. So, but in the end, the tribunal considered that one and it applied, but it surprised the parties maybe. That's why there was the question of challenge to the award. Wow. So I just wanted to add that.
Let me just add this. There's a recent speech, lecture by Chambao on Euronovid Arbiter, Truth or Fiction, which won the best lecture prize at GAR recently. And there's a lot of information in that. And one thing she refers to is that Gabrielle Kaufman-Kohler, in her procedural order, puts in that the tribunal can apply the principle Euronovid Arbiter. I don't know what happens if the parties don't agree to that, but that's what she tries to do.
Very fascinating.
It is. It's a great question. Yeah, Neil, just to remind that there are a number of questions on the chat, and if it's within your power to answer them or not, and we're happy to move on if that's your preference.
Yes, go on for a moment.
Yeah. Okay. So we'll proceed. It's Anna Gerdau's turn to ask a question. Anna, conscious.
Oh, yes, with pleasure. Yes, now moving to the parties' financial situation. Should the parties' financial situation, in your opinion, Neil, tailor or shape the procedures in an arbitration?
So
and to which extent, if yes?
So the question is, if one or both parties has limited means, should you scale down the procedure to make it as cheap as possible? In a sense, yes, I think. I mean, if you really know that that's the case, if both parties have limited funds and you could sit and they both want to get through this arbitration as cheaply as possible, then it's possible to sit down with them and come up with a procedure that's more economical. And you can have all sorts of things. You can get them to agree to limit cost recovery so that costs don't get out of hand. Cost is a real problem today. We see some huge bills of costs. And I've always wondered why we didn't have, ad valorem recovery of costs. Of course, nothing to stop parties agreeing that or limiting costs completely. There are a number of things you can do to keep the cost down. You can limit the number of rounds of submissions. You can put page limits on everything so it doesn't get out of hand. You can do as much as you can in writing so that there's no expensive main hearing. You can control the expert evidence phase if there is one to make sure it's much more economical. One of the things that I think we've been doing recently is using the experts at the end of the case as experts for the tribunal. Let me explain that for a minute in case people don't understand. Very often we have expert witnesses who are asking different questions and who are making different assumptions. They've been asked to make different assumptions. So they're like ships passing in the night. They're not madly helpful. But sometimes you get experts on quantum where there are 10 points of difference between them. And so you might want to decide 5 one way and 5 the other way. But then what difference does that make to the bottom line? Because you're not accepting all one side's points, and therefore their bottom line will be wrong. So what we found is very helpful is that when the experts have finished helping the parties with their closing submissions, we then invite the parties to agree that the experts will then become the experts to the tribunal on a confidential basis. The parties still have to pay their experts. But once you tell the experts how you're deciding these points of principle, then it's really very simple to come up with a bottom line figure. And that saves having another hearing to deal with issues of quantum based upon the findings in the award. And I've not known anyone object to that. And it's been very, very, very helpful.
Yeah, I was gonna ask if parties agree.
I've never known a party not to agree in about the 20
That's good news.
Yes.
May I here, if you allow me, Anna, to follow up on this question, and because you were talking about making sure that the process is about making sure that the parties should have a fair trial. What about a complete imbalance between the financial means of the parties? For instance, what do you think of a claimant with very limited means, which barely can afford the arbitration cost, and then you have a huge company as a respondent that files what is probably an abusive or ill-grounded counterclaim, which is going to inflate the arbitration costs? Well, it's one thing to say, well, don't worry, at the end, they will recover. If a claimant wins, they will recover the cost. But meanwhile, they still have to pay. What do you do if they can't and they have to stop the arbitration?
It's a problem. I've had that recently with an arbitration that was stopped in its tracks because one party couldn't pay and the other party wouldn't pay their part. It does happen. I mean, there's a limit to how far you can go. If you've got parties of disparate means, you have to put down a marker very early that costs will not necessarily follow the event, because if the bigger party, the successful party, the one with the money, spends a lot of money and increases the cost of the arbitration, they must be made to be aware that even if they win, they may not recover all their costs. It may not matter to them, of course, but I think you're entitled to put that marker down. It is a difficult one when one party hasn't got the funds to arbitrate. But I mean, it's the same as if they were going to their own national court or being taken to their own national court. They still have to come up with the money, or else there'll be a default judgment against them. So, I mean, there's a limit beyond which you can't go to help somebody. Of course, you can do little bits and pieces to ensure that the costs don't get too out of hand, and you can ensure that the impecunious party isn't put at risk of having to pay huge costs at the end of the day. But apart from that, there's not much else you can really do. You can use procedures, you can cut corners a little bit, but at the end of the day, even somebody with money is entitled to have their day in court if they want it.
Thanks, Neil. Let's hear from George then.
Yeah, well, just following on for that, and this really again leads really nicely into the next question. So, in what circumstances may or should the arbitrator act contrary to the procedural agreement of the parties? So, let's say, for example, let's describe this very similar situation which you're describing now, and the party with not as many funds has agreed a certain procedure. Maybe they're not that experienced, and you're looking at this as an arbitrator and you're saying, look, this is actually a small case. We don't need nearly as many steps as the parties have agreed to, or which are standard procedures of whatever the institution or the rules are that are applying. And no one's really thought, actually, we could do this a lot more efficiently. But you think that. But the parties have agreed something else, either in the rules or outside those rules. So are there any circumstances where you could act contrary to the parties' agreement? And could that be done in the name of justice?
Yes, definitely. I mean, this goes back to an old debate we used to have 25 years ago. Some arbitrators had this view that the arbitrators were the servant of the parties. Whatever the parties wanted, they had to do. Well, it was ridiculous, of course, because, I mean, you could have a case where the parties agreed that they would sit between midnight and 5 a.m. Are you telling me that arbitrators have to accept something like that? Of course they don't. And I think the arbitrators are now in a much stronger position to not to accept what the parties have necessarily agreed, because first of all, the arbitrators have an obligation in many jurisdictions to, they have a statutory duty to get on with the arbitration. So if the parties came to you and said, we've agreed, sir, statement of case 2 years, statement of defense 3 years thereafter, I think you might be justified in saying no, right? That's an agreement of the parties. You say, no, under this law that I'm applying, I have a statutory duty to proceed efficiently and expeditiously. And this is neither. So I think you are entitled to act contrary to the parties. For instance, you could say to the parties, particularly in an ICC arbitration, I'm thinking of appointing an independent tribunal appointed expert. Do you have any comments? And they could both say, no, we don't want you to. You're perfectly entitled to appoint one, because the ICC rules say you can appoint one after discussion with the parties. You've had the discussion with the parties, they've said no, so what? If you think it's appropriate, you can do it. And of course, from a practical point of view, if the parties come to you and say, we've agreed this, and you say, well, actually, I don't think that's a good idea for these reasons, one of them will break ranks. Almost inevitably, one will break ranks, and then you have got that problem. But if they do come to you and say, we've agreed this procedure, and you think that procedure is quite wrong and inappropriate, I think you're entitled to say no. I don't think we are bound by what they do, bearing in mind the statutory obligations we have.
But obviously only after a discussion with the parties, and there may be reasons that the arbitrator didn't appreciate in the beginning why they agreed to some certain procedure, of course.
I think you say to the parties, look, I'm very unhappy about this. I need you to discuss it and show me why it's really necessary. And then in the course of that discussion, either you'll be convinced or you'll convince them.
Yeah, no, that makes sense.
Excellent. Okay, well, thank you so much, Neil and George, for that exchange. And it's now a third question from Jill, please.
He's gone.
Just, yeah, sorry, again, going back on unmute. A topic that you and I very much like, Neil, Zoom. I was wondering, now that we have some distance with what has happened during the pandemics, what do you think has been lost in virtual arbitration hearings vis-a-vis in-person hearings? I'm sure everyone agrees that there are benefits, but the question is, what do you think, very practically speaking, we may have lost, and how do you think we can recover those, even in a virtual setting, i.e., assuming we don't go back to a systematic in-person hearing?
Well, the thing I miss most is being able to sit down with you and having a drink or lunch or dinner, discussing a case. It's the human contact, I think, has been the hardest thing to bear. And I think also the adrenaline, there's so much more adrenaline involved in having a face-to-face meeting around the table with all the interaction. It's much less adrenaline speaking to you across the airwaves like this, sitting in one's own home or wherever, hotel room or whatever. It's not quite the same thing. I think the answer to your question, though, is this. It depends whether you're talking about it from the arbitrator's point of view or the parties or the advocate's point of view. I think from the arbitrator's point of view, the general feeling is it works perfectly well. Now, here I am. Let's assume you're a witness. I'm looking at you very carefully. I'm much closer to you now than if we were in a hearing room. and I can tell immediately whether you're telling the truth or lying, just by just looking at you. No, I mean, the fact is, I see you, I can hear you, and it's fine. From an advocate's point of view, I think it's quite difficult because you've only got the witness on the screen. You're not able to look around the room to see how your questions and the answers are being viewed by all the other people in the room. And there's a lot, I think, that the advocate misses. One of the advantages is, I think, time keeping is much better on Zoom. Somehow we seem to be much better at sticking to the time schedules. There are some cases that are not really appropriate for a Zoom hearing. A really complex construction case with experts, with plans and maps and photographs, those sort of things are quite difficult to do on Zoom. But anything to do with law, legal submissions, or straightforward facts, I think are fine. The biggest disadvantage, of course, is the tyranny of timescales. I've done several cases where 5 o'clock in the morning until 9 o'clock in the morning, and others have sat all night. That's the price you pay for not flying halfway around the world.
Neil, if I have to follow up very briefly on your on two other points you've made, the lesser adrenaline and the fact that the perspective may be, or the answer may be different according to whether you're talking about arbitrators or advocates. Would you say, in general, that the advocacy skills are less effective in a virtual setting?
I think to some extent, yes. They are limited a little bit.
I mean, have you seen the same the same lawyers pleading in front of you in the real life versus in a virtual setting? And have you found any difference, or have you considered that they may be, at least to some extent, less effective in convincing you?
No, I can't say I have. No, I can't say I have.
Without giving names, obviously.
No, I don't think I could say that, no. I think the cases that I've done on Zoom have been perfect for Zoom. They've been quite compact cases, you know, with limited issues, and we've been able to deal with it very conveniently. But a big, complicated construction case, I think, would be a disaster. And that's why most of them have either settled or adjourned for ages.
Thank you. Thank you.
Yes, thank you very much, Jill and Neil. Just to recall, I see you, Neil, are looking at the chat function as and when you want to attend a question, you're most welcome to. We have two other scheduled questions, and I see that we are more or less on time. As you say, over Zoom, one does have that advantage over the virtual platforms, not just Zoom. Neil, are we heading on to the next scheduled question?
I see a question here. It says, do you think it appropriate for arbitrators to understand or even inquire as to what, if any, procedural expectations led the parties to nominate them? That's an interesting question. I don't think you can do anything other than guess. I don't see how you can answer that question. I mean, that actually leads to a point that I'm quite keen on, and that's whether or not we should have blind appointments, whether we shouldn't know which party appointed us. And that can be done quite easily. So party A wants to appoint Jalal, so they contact an institution and say, we want to appoint Jalal, you please appoint him for us. So he gets appointed. I've chosen him, but he doesn't know I've chosen him, because he's appointed by the ICC, SIAC, or whatever. And therefore, he will not know which party appointed him. And I think that is actually quite an advantage. And we have this provision in Mauritius for blind appointments, and one of the American institutions has a provision for it. And I think there's quite a lot to be said for it. Hasn't gained a great deal of traction. I mean, to some extent, you better guess who appointed you, but that's not the same thing as knowing. And that raises the question of the whole role of the party-appointed arbitrator, which no one's asked me about yet.
Thanks, Neil. May I do that?
That's my question coming up. So.
Oh, okay. Yes, let's hear from George next. Yeah. Uh-huh.
I mean, as you asked to be asked for it, here's the question. So, do you agree that in practice, the co-arbitrators are almost always, or at least with noticeable frequency, more sympathetic to the party which nominated them? And should there be a lower standard of impartiality for co-arbitrators than there are on the chairman?
Well, let me just turn the question round a bit. It was always said that the party-appointed arbitrator's only duty was to ensure that the parties who appointed him or her case was properly understood by the other two members of the tribunal. And that was a view to which I subscribed for many years. But I've changed my mind, partly because I was convinced by a lecture given by, again, Sundaresh Menon in Singapore, where he said that that's ridiculous, really, if you think about it, because let's assume you're a party-appointed arbitrator and you're sitting down with the other two and you say to them, now I want you to make sure that you understand the case. The case they're saying is this, and then you have to say, but I don't agree with it. I think it's rubbish. I'm going to vote the other way. It's nonsense. I don't think you can have any differing roles. You're all independent and you must remain independent all the way through. Going back to the first part of your question, one has to be very careful as to how one answers this. I mean, I've always been impressed by the research that Albert Jan van den Berg did when he looked at 34 dissenting judgments, dissenting awards in ICSID cases, and every one of them was by the arbitrator appointed by the losing party. And I said, I think that speaks volumes about the role of one party who's been appointed, the party appointed arbitrator. Do I find it? Do you know what I think? I think in the initial skirmishes about this and about that, you do tend to see a little bit, you know, gosh, I'm not surprised he's saying that. Look who appointed him or her. But as the case evolves and you get down to the nitty-gritty, I think that disappears. I mean, occasionally you get the odd party pre-arbitrator, which is a terrible thing because it ruins that party's case because the other two arbitrators just ignore them. So it's counterproductive. But I think generally, even if there's the odd sort of statement you get procedurally to assist a party that appointed that arbitrator, as you get into the real thing, I think that evaporates. And at the end of the day, I think you can have a pretty good discussion. I'm not saying there are some arbitrators who, you know, their life might be in danger if they decided against the party who appointed them. You know, you do get situations like that, or their life will be made a complete misery. So you do get that too. But generally speaking, certainly in the cases I do, we very rarely have a dissent. I've only dissented once in my life. And I always try and stop my co-arbitrators from dissenting. I mean, they can disagree and you can say, Mr. X doesn't agree on this point or doesn't agree with the majority on this point, but there's not much point in having a big dissent. Dissent's not worth anything. Who are you dissenting? What's the point of writing a dissent? Who is it for? Just to show the party who appointed you that you were with them all the way? That can't be right.
Well, I mean, that's the interesting question why you mentioned in the exit cases. So there, the dissenting opinions do serve perhaps some more of a public purpose if there's a principled dissent for some legal or academic reason, and they are read, for future cases. So there might be some reason, but in a private, confidential, usual commercial arbitration, I can see they serve less of a
you make a valid distinction there. I should have picked that up myself. I mean, in exit cases where you're dealing with public policy and important points of international law, sometimes you just want to lay down a marker that you don't agree and that it come up again. That's fine. But otherwise, it doesn't. In a commercial case, it doesn't really make any difference. As Alan Redfern pointed out in his Freshfield lecture some time ago. Have I answered your question?
Yes, thank you very much. Thank you.
Well, thank you, George, and thanks again, Neil. We have one final scheduled question, and Anna Gerdau is going to ask it of you, Neil. Please, Anna.
Yes, the last question would be, what, in your opinion, are the most important goals of an arbitrator when acting as such? One could think of possible goals to consider the parties' arguments and the facts, to decide in a didactic, convincing fashion, to develop the law, to consider the parties' expectation, avoiding surprise decisions, as you mentioned a minute ago, to decide expeditiously, and to avoid challenges to the award, among others. What are, in your opinion, are the most important goals of an arbitrator?
I think, well, it's not an answer. Let me just start by saying, I think awards are far too long. And the reason I say they're far too long is because they're not judgments of a court. They're not PhD theses, doctoral theses. And if they're written in that vein, then the person writing them is out of line. What I think an award should do is explain to the losing party why they've lost, and explain sometimes to the winning party why they haven't won as much as they thought they were going to win. And I think you should set it out very simply. You should tell a story. Every case is a story. Every dispute is a story in its own right. And I think you should avoid too much cutting and paste. I think that the awards are too long because they set out what the party said in this document and in that document and the reply document, and then you set it all out again when you deal with it. So it seems to me that the people writing awards have lost the art of précis, of summarizing what people say. And I say this, having been on the ICC court for 4 years, when you have to read these things and you see a fairly simple commercial dispute, and then, it takes 500 pages to resolve, whether the goods were delivered on time or not. It's got right out of hand because of cutting and pasting. And I think to some extent, some of the institutions have contributed to this by requiring so many I's to be dotted and so many T's to be crossed. For instance, the procedural history should never be in the award. The procedural history is a matter of record anyhow. It should be in an annex to the award. And that'll knock 50 pages off the award you have to read. And I think you're telling a story. And it has a beginning, and it has an end, and it has a dispositive. And I think if you've written judgments, it's a lot easier because you're used to setting out what's happened and telling a little story and coming to a conclusion at the end. I've found too many of the awards I have read are really philological exhibitionism. you know, trying to show how clever the author is. Now, one of the things in the Mauritius rules that we put in was that the award shall be succinct. Now, if you have a provision in the rules under which you're operating, which provides for a succinct award, then hopefully no court's going to refuse to enforce or set aside that on the grounds that you didn't set out everything conceivable. So I think you know, to some extent, you want to let the losing party down as gently as you can, as gently as the facts allow you to, and explain why you didn't accept their evidence and why you didn't accept their legal submissions. And I don't see there's any point in being nasty to people. And when you write an award, you just come to a conclusion. Sometimes it's unfortunate, but there it is. And you know, you don't want to stoke up the fire by writing an award that increases passions rather than smooths them over. I don't know if that is an answer to your question. Or do you want to follow up at all?
Indeed, so.
All right.
I think it's an art to be succinct, and I imagine one develops that with time.
Right.
Yeah. Neil, is there something further you'd like to add? Because we've come to the end of the scheduled questions. And I noticed the hour, we're more or less on time. We've slightly overextended.
I'm just looking at a question here. The arbitrators and the advocate's view of the difference between physical and virtual. Is there something about the witness? Isn't the court case the witness hearing with a witness? I'm not sure. I mean, there's this question about virtual hearings as well. One in Australia, you know, we had a lockdown for a long time. So even the courts had lots of virtual hearings. And most of the judges I spoke to have found the virtual hearings work very well for them, because for the reasons I gave before, they felt very close to the witness, and they didn't feel in any way disadvantaged by the witness not being in the same room. And as I said before, I think that might be slightly different for the advocate, but I can't answer that as I don't do advocacy anymore. But I think it's nicer to be an advocate when you've got everybody around you in the same room. But there's new technology coming, I think, that will enable our Zoom hearings to look like you're all in the same room. I don't know what it's called, but I look forward to that. That might be quite a good thing. I mean, I don't think we're ever going to return to the old days of flying halfway around the world for a half-a-day procedural hearing. I mean, procedural hearings, submissions on law, that can all be done like this quite nicely. I think it's only for the major witness hearings that we really have to get together again. But we'll see. Other people might have different views. You're mute.
Thank you. I am indeed. Well, thank you. Thank you so much to our distinguished guest, Neil Kaplan. And I don't want to give the impression I've lost the art of succinctness in summarizing. I'll say this. One feels very fortunate to have had the benefit of reviews today. There's an obvious amount of expertise, not just the years with respect, but also the geographical acquaintance you have, Neil. And as arbitrators, we all would like to feel that we're like Athena, born fully formed, helmeted and ready to do battle. But today has certainly demonstrated the great advantage of experience and judgment, leavened judgment. So I do say one feels very fortunate to have heard you today. And so thank you sincerely. Thanks to our panelists for your very pertinent and thought-provoking questions. And thanks to our participants for joining us. That concludes this year's European Branch Chartered Institute of Arbitrators annual conference. And we look forward to seeing you again in a year's time, hopefully in the flesh. Thanks for joining us. Bye-bye.
Bye. Bye.
Goodbye.
Thank you.
Bye-bye.
Thank you, Neil.
Bye, Joe.
Thank you, Philippe. Goodbye.